To tell us more about Rex Education and to officially open today's event, let us hear from Rex Education's Chief External Affairs Officer, Ms. Donna Crimelda I.
Buhay. Good afternoon and welcome, everyone. With 70 years of service and dedication to education, Rex now evolves from the iconic bookstore that we all know to something bigger and more significant. We are now Rex Education, a brand, a community, an advocacy, a tradition of service dedicated to inspiring every Filipino lifelong learner to advance themselves and uplift others. We have gone from just providing learners with published materials to accompanying them through their lifelong journey, learning in all forms, beyond the walls of institutions, learning for delight, and enlightenment and fulfillment. True to its tradition of service, Rex Education is guided by the Edu-Campion philosophy, which seeks to rally and empower education duty bearers. An Edu-Campion is a champion for education who works with the best interests of the Filipino whole learner in mind. Under this philosophy, Rex Education seeks, among others, to empower duty bearers in the field of education to champion education no matter what the circumstances are. It is through and because of this that we are excited to spend the next 2 hours with you as we come together to unveil our most updated offering for the Philippine legal community. Psychological Incapacity, a genuine happiness and authentic grief of marriage, its nullities, and clinical basis, which tackles some of the major issues surrounding the grounds for the declaration of nullity of marriage, focusing more on Article 36 of the Family Code under psychological incapacities and its clinical and legal basis. The discussion in this book are carefully dissected and scrutinized so that even a lay learner can understand each case and the uniqueness of the facts and cases. I have the honor to present the honorable man behind this book. He is the senior partner at Edinburgh Tumuran Law Offices, a real estate law practitioner, and he was a former board member of the Integrated Bar of the Philippines, Calmana Chapter. A former professor at FEU, IABF, and in addition to these, our author is also an active triathlete and a painter. Friends, join me in welcoming our partner in championing legal education, Attorney Edinburgh P. Tumuran. Good afternoon, sir.
Good afternoon, Mama. Thank you very much for that wonderful introduction.
Good afternoon. Thank you. Thank you so much.
Thank you so much, ma'am. Now, before we start, I would like, of course, to acknowledge, give thanks, of course, to the Lord that's given me this opportunity to write this book. And, of course, I would like to thank the people behind this book, Attorney Dominador Buhain, Mr. Don Timothy Buhain, Mr. Roger John Fontelera, Mama Dandan Buhain, Miss Jean Torcedillas. Thank you for the opportunity given me in having one of your partners in this endeavor. And of course, I would like to give thanks also to those people who were helping me while we were preparing this book. The team who actually guided me in all of those editing and everything, and of course my wife, who is a psychologist, has given me so many inputs as to this the psychological incapacity and all those disorders. And also I would like to thanks also Attorney June Tagapan, who is it cannot be there will be no stipulation as far as the marriage is concerned. However, we will discuss further what are the limitations or the exceptions as to the stipulation. Now, Family Code took effect on August 3, 1988. Okay, now before we go further into the discussion of the Article 36 of the Family Code, we should first examine the definition of marriage. Under Article 1 of the Family Code states that marriage is a special contract of permanent union between a man and a woman entered into in accordance with law to establish a conjugal and family life. Okay? It is a foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation. Take note, not subject to stipulation. However, there are exceptions. Exceptions that marriage settlement may fix the property relations during the marriage within the limits provided for by law or by the family code. Now, marriage special contract, meaning compared to an ordinary contract, let's say a contract of lease for that matter, whereby any person can enter a contract of lease, both male and female or both sexes. It depends because the issue there is the renting of the house. Unlike in a marriage, it is a special contract. It is also permanent. Okay, a contract between a man and a woman only. Okay, to establish what? Conjugal and family life, and its nature and consequences. These are governed by law and not subject to stipulation. However, parties can the future spouses can always enter into a contract, prenuptial agreement. Okay, they enter either absolute community, conjugal partnership of gain, or absolute community, or any other contracts as pertaining to their properties. Combination of these three. Okay, so that's why in one case, this is a classic case of Nove versus Pinciotti, a 1942 classic case in the United States. There was a contract, an agreement between these two individuals, wife and the man and the woman, whereby they agreed that the woman should bear child so that their marriage will have to continue. And it later on found out that the wife would not bear child, so therefore the husband seek declaration of nullity of marriage. The court in the United States declared such contract as void, considering that there can be no contract as far as the marriage is concerned. And the court in the United States considered such agreement as void and declared that the marriage is still valid. Okay? Now, if a man or a woman will enter into a contract, can there be a breach that may be had by one of the parties in the event that one of the parties later on decides not to pursue with the contract? Technically, a mere breach of promise to marry is not an actionable wrong. Meaning, if you promise to marry your girlfriend or the girlfriend promises to marry the boyfriend, mere promise is not an actionable wrong. So therefore, the future husband or the future wife cannot go to court simply saying that there was a promise for them to get married. However, if this promise is coupled with preparations and everything, you have sent so many invitations to your friends, relatives, and you have already made reservations and payments to your reception, then that will now be considered an actionable wrong. Okay. Now, in one of the cases recently, in the case of Jesus Nicanor, Palsis versus Civil Registrar General, GR number 217910, September 3, 2019. A petition was brought to the Supreme Court for this so-called same-sex marriage. Now, the Supreme Court dismissed the petition, stating that the issue of locus standi, because the petitioner has no personality with respect to this same-sex marriage, and also the Supreme Court states that there is a need for Congress to address the same-sex marriage. Okay? In fact, in the Family Code, under Article 1, it is a contract between man and a woman. So therefore, same-sex marriage is totally out of the question right now. No? Now, going back to now, we will jump to our discussion, the psychological incapacity and its personality disorders. Now, under Article 36 of the Family Code, it says that marriage a marriage contracted by any party who at the time of the celebration was psychologically incapacitated to comply with the essential marital obligation of marriage shall likewise be void, even if such incapacity becomes manifest only after its solemnization. Okay. Now, take note that psychological incapacity must be a very grave and serious matter, whereby it can be considered as grounds for void marriages. Okay. As in some case, sexual infidelity, repeated physical violence, homosexuality, physical violence, or moral pressure to compel one of the parties to change his religion or affiliation, and abandonment on grounds. These are merely grounds for legal separations, because the Article 36 is so strict as far as this psychological incapacity is concerned, meaning that it should exist prior to the marriage, and such incapacity may only manifest during the marriage, meaning the psychological incapacity is already ingrained in the person, and even if he will enter into a contract of marriage several times, still, in my opinion, he will remain as such if there is no a declaration of the court to that effect. Okay. Now, take note, in one case of Lim versus Cruz Lim, GR number 176464, February 4, 2010, the Supreme Court says that a judge should not substitute his own psychological assessment of the parties that of the psychologist or the psychiatrist. Certainly, as in all other litigations involving technical or special knowledge, a judge must first and foremost resolve the legal issue based on law and jurisprudence. Meaning, even if there is a clinical psychologist that may be presented by the petitioner or by the respondent for that matter, still the court can always consider such evaluation of the psychologist or clinical psychologist to be inaccurate, and therefore the judge has the sole prerogative to declare now, to determine whether a petitioner or a respondent for that matter is suffering from psychological incapacity, that their marriage may be declared as null and void. Now, all grounds for nullity of marriage should be alleged in the same complaint. Now, if you allege psychological incapacity and then you found out later on that there is no marriage license, you fail to include that in your petition. In one case of Malion Alcantara, GR number 28, October 31, 2006, the Supreme Court considered such failure of the petitioner to include one of the grounds for declaration of nullity of marriage as a waiver. So therefore, he cannot later on file a petition saying that I failed to include in my petition that there was no marriage license, so therefore the marriage is void, something like that. So the Supreme Court considered the same as a waiver on the part of the petitioner. Now the law requires to render the marriage void on the ground of psychological incapacity is downright incapacity, not refusal or neglect or difficulty, much less ill will. The mere showing of irreconcilable differences and conflicting personalities does not in itself considered as a psychological incapacity. So therefore, it is not the physical incapacity that can be considered by the court, but the psychological incapacity. We will go later on to this personality disorder. Now, psychological incapacity always involves personality disorder. Although the framers of the family code, during the time that it was being evaluated, they did not include therein the grounds. They did not specifically mention there what are the grounds or what. In fact, they did not make any definition, specific definition of the psychological incapacity. Now, the reason being is that the framers of this family code did not want to place a barrier as far as this definition of definition and grounds psychological incapacity. So it's an evolving thing actually, and there will be cases in the future that will be decided by the Supreme Court that will somehow level up what is the definition of psychological incapacity and what are these personality disorders. However, for purposes of this discussion of this book, personality disorders are a class of mental disorders characterized by enduring maladaptivity pattern of behavior, cognition, and inner experience exhibited across any contexts and deviating from those accepted by the individual's culture. Okay, meaning the person is always something that is out of the ordinary. He is not a typical individual that we know. In short, he possesses some sort of a personality disorder. Okay, now one of the causes of personality disorder is through the time that a person is being brought up as a child. Even his environment, it somehow affects his personality disorder. Or if he is suffering from any psychological incapacity and he has some personality disorder. Also his parents, the way he was brought up by his parents while he was still during his growing years, this also affects his personality. It will somehow develop into a psychological incapacity. Now, psychological incapacity, this is, there are actually 3 clusters in this one. We have here the cluster A, the eclectic or odd, meaning a person is quite different from individual. No? Person with this disorder exhibits behavior that others perceive as strange or erratic. Now, under this cluster A, we have here the paranoid personality disorder. Now, people who are suffering from this disorder are those people with to have difficulty trusting others, no? Even without any reason or reasonable suspicion. Meaning, person who is always suspicious, no? He thinks that he cannot trust everyone. He is suffering from paranoid personality disorder. But take note, not all people have personal disorder. They may have trait. Okay, trait is different from a full-blown person suffering from psychological incapacity. Another one is schizoidal personality disorder. Okay, patient with this disorder often hear voices, believe everyday occurrence are really hidden message from them. Okay, we have here another one is the schizoid personality disorder. This disorder makes people reluctant to be around others, okay, making them seem cold and unapproachable to others. Okay, they are quite aloof somehow. And another one is this cluster B, the eclectic or the dramatic cluster. People with this type of personal disorder displays unpredictable behavior and react dramatically to seemingly mundane events. Okay, and one of which is the antisocial personality disorder. People with this disorder have little to no regard for the needs and emotions of others. Meaning they don't really mind what people would think of the reactions. So. And another one is this borderline personality disorder. People with this personal disorder have fragile egos and believe that the people they love will abandon them. Okay. Historic personality disorder. This disorder is marked by a constant need for attention. Okay? Meaning, parang in our term in Tagalog, yung KSP, no? They tend to get some attention all the time and they don't really mind what attention they would, or what people would react, no, in having this, getting this attention. Now, another one is this very famous, the narcissistic personality disorder. This personal disorder will believe their needs and feeling of more important than others. No? Meaning, they feel like they are superior from the others. No? They also get attention. No? Even if it is not true, they somehow feel that they are superior than the others. Now, lastly is the cluster C, the fearful or the anxious. No? We have here the avoidant personality disorder. This disorder makes people terrified of rejection or any criticism. Okay, so meaning people who are feared of that they may be criticized somehow in what they're doing. So they don't want to be criticized. They want affirmation on everything that they do. They do not derive any satisfaction if they are rejected. Okay, dependent personality disorder. People with this condition are motivated by the fear of having to take care of themselves or make decisions. Such they depend on others to take care of their needs, make decisions, and give them constant approval. This is a person who has this dependent personality disorder is somehow dependent to some individuals. No? They always want, they cannot decide on their own. They would ask their spouses for a certain decision. Lastly is the obsessive-compulsive personality disorder. People with this disorder take reflection to extreme levels, no? Or rather perfectionism to extreme level. Okay, they feel that they want everything to be in order, perfect situation, just like in their house. They want things to be in order, even a simple arrangement of chairs and everything. They tend to have their own level of perfection. Okay. Now, in one case, the case of Reyes versus Reyes, GR number 185286, August 18, 2010. Supreme Court said that patient with antisocial personal disorder can often seem to be normal and even charming and ingratiating. Okay? Their histories, however, reveals many area of disordered life functioning: lying, running away from home, theft, fight, substance abuse, and illegal activities, and typical experience that patients report as beginning in his childhood. Meaning the psychological incapacity is part of the system of this individual. Now, another classic case of this Chiming Choi versus Court of Appeals, GR number 119190, January 16, 1997. In this case, when the parties got married, they did not engage into any sexual intercourse, and so the wife remained virgin. And then, because of that fact, the wife now filed the case of declaration of nullity of marriage under Article 36 of the Family Code for psychological incapacity. Now, the Supreme Court said that the fact that the wife is still a virgin only proves that there was no sexual intercourse that happened during their marriage. And that fact of the husband that failed to have the sexual intercourse is in itself the basis for his psychological incapacity. Okay? As compared to a situation whereby the husband is impotent, okay? He cannot consummate the sexual act. This is different because the petitioner herein was never impotent, but they did not consummate the sexual act. Therefore, he was declared as suffering from psychological incapacity under the Family Code, under Article 36 of the Family Code. Now, take note that in dissolving marriage bond on account of either party's psychological incapacity, the court is not abolishing the foundation of the family, but it is actually protecting the sanctity of marriage. Even if the court will declare the marriage as void, whereby one or both parties are suffering from psychological incapacity, it is not actually demolishing the marriage. It is in fact somehow protecting the sanctity of marriage. Because if the parties can no longer be together and live as husband and wife, and at the end of the day, the relationship will suffer, and of course, the children will be affected by reason of the incapacity or psychological incapacity of both the husband or the wife. Okay. Now, take note that under Article 26, it is a void marriage. It will not prescribe, whereby as compared to a voidable marriage, which can prescribe. Okay. One of the examples of a void marriage is that if one of the parties is a minor, okay, that is a void marriage. Okay. Also, what we call the marriage by reason of void by reason of public policy. A marriage between two individuals who are first cousins, okay, or in the legal terms, within the fourth civil degree. This is a void marriage, example of a void marriage, because there's a proven in science that first cousins would somehow have this, a child will be maybe born out of this marriage, may be suffering from any sickness or ailment. Okay. Now, in one of the jurisprudential case of Republic of the Philippines versus Molina, GR number 108763, February 13, 1987, the Supreme Court made the guidelines for the bench and bar for the interpretation and application of Article 36 of the Family Code. And there are 8 actually. No? One is the burden of proof to show the nullity of the marriage belongs to the petitioner or the plaintiff. Meaning, if the petitioner files a petition for this declaration of nullity of marriage, he must prove it in court. Otherwise, if he cannot prove it, then the petition is or may be dismissed. No? Root cause of the psychological incapacity must be medically or clinically defined. Okay, alleged in the complaint, sufficiently proven by expert. Although we will go later on as to this expert testimony. Clearly explained in the decision. Okay, so there must be a proof of the psychological incapacity. Although technically, in so many decisions of the Supreme Court, it does not require the presentation of the clinical psychologist. It is not actually mandatory. So long as the totality of evidence can be proven by the petitioner or by the plaintiff that the respondent is suffering from psychological incapacity, and the court so believes, and evaluating the piece of evidence presented by the petitioner that the respondent is suffering from psychological incapacity. So therefore, the court can always decide, even if the can be dispensed with the testimony of this clinical psychologist. Although the testimony of the clinical psychologist will somehow help the court. The court will be guided by some technical matters pertaining to personal disorder. And of course, that is an added point as far as the petitioner is concerned. Going back, the incapacity must be proven to exist at the time of the celebration of the marriage. Right? Meaning, it must exist during the celebration, and also it will only manifest during the marriage. No? Such incapacity must also be shown to be medically or clinically permanent or incurable. Okay? Although there is another ruling recently in Tan Andal versus Andal, we will discuss that later on as to this matter of being incurable and permanent. Such illness must be grave enough to bring about the disability of the party to assume the essential obligation of the marriage. No? Well, of course, under also number 6, the obligations of the spouses under Article 68 of the Family Code does not exist also. Okay, interpretation given by National Appellate Matrimonial Tribunal or the Catholic Church may also be given persuasive effect, but it is not conclusive actually. And of course, lastly, the Office of the Solicitor General, through the prosecutor's office, must always intervene. They will intervene not to protect the interests of the parties, but to protect the interests of the state. Because, as we have stated earlier under the Constitution, that marriage is inviolable social institution and is protected by the Constitution. Okay. Now, under Article 68 of the Family Code, says that the states that husband and wife are obliged to live together, observe mutual love, respect, and fidelity, and render mutual help and support. Now, take note that under Article 36, all of these attributes should not be present before a marriage can be declared as void under Article 36 of the Family Code. No? Meaning, they are not living together. They are already separated. They do not observe mutual love and respect. Okay? Fidelity. No? They are no longer sleeping together. And they do not render mutual help and support. Okay? Now, all of these are actionable wrong. However, if one of the parties is involved with another person, third person, that is probably sexual infidelity, it can be considered as concubinage as far as the wife is concerned, or concubinage as far as the husband is concerned, and adultery as far as the wife is concerned. This is an actionable wrong. Okay. In fact, a case can be filed against the erring spouse. However, there are attributes under Article 68 that are not actually actionable. Example, that is love. Can you go to court and demand that you be loved by your husband and by your wife? That is not possible. Okay? And live together. Although under the Family Code, it states that the husband and wife should live together. Save of course, some exceptions whereby the husband or the wife will live outside of the conjugal dwelling, not because of choice, but because of necessity, such as the wife is probably working in the province or abroad, or so with the husband. The husband is working in the province or abroad. But if the husband leaves the conjugal dwelling and files a case of declaration of nullity of marriage under Article 36, then the wife cannot file a case in court and compel the husband to go back to him. Okay. Now, in the jurisprudential case of Santos versus Court of Appeals, this is the first case that came out that was decided by the Supreme Court on January 4, 1995 under GR number 112019. Okay, it says that psychological incapacity must be characterized by 1, gravity, juridical antecedent, and incurability. Now, incapacity must be grave or serious such that the party should be incapacitated to carry out the ordinary duties required in marriage. Okay? It must be rooted in the history of the party antedating the marriage. No? Meaning, even before the marriage, this person is already suffering from psychological incapacity. Even he was still growing up, he is already suffering, or rather, this personal disorder is already developing while he was growing up. Okay, and although it must be rooted in the history of the party antedating the marriage. Okay, although the overt manifestation may emerge only after the marriage. Okay, and it must be incurable, or if it is curable, the cure is beyond the contemplation or reach of the parties. Now, take note that a person who enters into a contract of marriage may appear to be okay without any inkling of personal disorder, and it somehow during the marriage that he exhibited some traits or attributes of personal disorders. That's part of those clusters A, B, and C. Now, even if he was doing well before the marriage, he can be considered as psychologically incapacitated because the psychological incapacity only manifested during the marriage. That's like in the classic case of Marcos versus Marcos, whereby they were the relatives of the former president, and then they were doing okay while the President Marcos was still here. Now, when the revolution took place and the Marcoses left particularly the first family back then, this couple now was left here in the Philippines, and the husband now became miserable because of the fact that his relatives went under exile by the government back then. Now, and then he started to quarrel his wife, and things went wrong, so the marriage collapsed. And then they filed a petition for declaration of nullity of marriage. In that case, the Supreme Court said that the husband was not psychologically incapacitated. Why? Because during the time that they before the marriage, during the time that the Marcoses were still here, he was doing okay, and then he became somehow his character became odd when the Marcoses left. So meaning this is not psychological incapacity, but this is only physical incapacity as declared by the Supreme Court. Okay. Now, we will discuss this case of Tan Andal versus Andal. The recent case decided by the Supreme Court May 11, 2021, GR number 196359. In this case, although we have yet to read the entire decision, I have not yet. I have made some research as to the release of the decision, but there's no decision yet that is being released by the Supreme Court. However, it says here that the court pronounced in this case that psychological incapacity is not a medical but a legal concept. It refers to a personal condition that prevents a spouse to comply with fundamental marital obligation. Only in relation to a specific partner that may exist at the time of the marriage but may have prevailed through behavioral consequence to the ceremonies. Okay, this is basically the same. Okay? Basically the same. The manifestation only, or rather, the incapacity only manifested during the marriage. Okay? As it goes further, the ruling goes further and says that it need not be a medical or personal disorder. Okay. This is quite controversial because psychological incapacity is, although as stated there, it is now a legal concept. Okay. So meaning this one, when it says that it need not be medical or personal disorder, meaning this is still in consonance or in sync with the definition, or rather with the wordings of the Article 36 of the Family Code. Meaning there is no definition yet. So meaning any grounds for that matter, so long as the court will determine that such behavior falls within the purview of Article 36, then it need not be personality disorder. Okay? Or need not be a mental disorder. No? It need not be permanent or incurable condition. Going back, this ruling speaks of something about a specific individual, meaning a person or the husband may be psychologically incapacitated as far as his wife is concerned. This is now what's being referred to. Although I have yet to read the entire decision, but this is somehow the reading between the lines, no? Meaning a person may be psychologically incapacitated as far as his wife is concerned, or as far as her husband is concerned. Okay, but need not be psychologically incapacitated if he will be dealing with another individual. Okay, and that is still goes within the contemplation or meaning of the Family Code. And lastly, it says that the totality of evidence must show clear and convincing evidence to cause the declaration of nullity of marriage. Again, this is also true, and it also further says that testimony of psychologists or psychiatrists is not mandatory in all cases. Again, this is true. There are so many cases rendered by the Supreme Court that there is no need for any clinical psychologist testimony or the psychiatrist, so long as the totality of evidence can be established by the petitioner that the respondent is suffering from psychological incapacity. So therefore, the court can always rule in favor of the nullity of marriage. No? in favor of nullity of marriage. Or even the court can even declare both the husband and the wife, both are suffering from psychological incapacity. Although again, there is a need for us to read first the entire decision of the Supreme Court before we can possibly dissect each and every obiter dictum that was laid by the Supreme Court. Okay. Now, root cause of psychological incapacity need to be alleged in the petition. Excuse me. The petition must be, or rather, the root cause must be alleged in the petition. Otherwise, if the petition is lacking as to the source of the incapacity of the respondent, then the petition is or maybe dismissed. Now, one question is a valid question may be asked now. Okay, can a psychologically incapacitated individual enter into a contract of marriage again, or can he or she remarry? The question is, of course, yes, but of course, the future spouse, if a person is declared suffering from psychological incapacity, applying the Tan Andal versus Andal case, then such person may be psychologically incapacitated as far as his former wife or husband is concerned. But he need not be psychologically incapacitated as far as his future wife is concerned. Probably they can go into a harmonious marriage, or second marriage. But then again, of course, in my opinion as a practitioner, I can always say that the person suffering from psychological incapacity will always be as such. Why? Because it is already ingrained in his system. In fact, when he was growing up as a person, until he reached the age of majority and went to college, had his job, and eventually married and had his family, then this psychological incapacity is already ingrained in his system. And so therefore, he will always be psychologically incapacitated. And so therefore, any person who will contract a marriage from a person who was already declared psychologically incapacitated, he is given a warning. He is given a warning whether to proceed with the marriage. But then again, if they can always establish a conjugal and family life peacefully, then I don't see any problem with that. Can the wife ask moral damages from the husband? The wife files a case of psychological incapacity under Article 36 of the Family Code. And then he asks now damages from the husband. Is that possible? That is not possible. Why? Because it's quite an absurd situation whereby the damages that will be awarded by the court will also come from the absolute community or from their properties. Try to imagine you will be awarded moral damages against your husband, okay? And where will the husband get the payment for the moral damages or exemplary damages? It's coming from the conjugal property. It's just like getting your money from your left pocket and putting it in your right pocket. It's quite absurd. It's not really practical and without any basis. Now, in the book, I have also discussed this prejudicial question. It is also important because in some situations, the husband, or rather the wife files a case of declaration of nullity against the husband. Okay? But, or rather, let's put it this way. The husband enters into a contract, second marriage, okay? And so therefore, the wife files a case of bigamy against the husband. And then the husband now will file a petition for the declaration of nullity of marriage, of the first marriage, so that in the event that the first marriage will be declared null and void, the second marriage will be considered as valid. And so therefore, there is no bigamy or concubinage, as the case may be. That is not possible. Because take note that before you enter into subsequent marriage, take note that your first marriage must be declared is either void or voidable by a competent court, competent court with the finality of the decision. Otherwise, even during the pendency of the case, you file a petition for declaration of nullity of marriage, and then while it is pending, you contracted the marriage, then that can be considered as a bigamous marriage, even if later on the first marriage will be declared as null and void. But take note that if a person will secure a decision that his marriage is declared null and void under Article 26 of the Family Code, he must enter into a contract of subsequent marriage. It must be after the finality of the decision of his first marriage being declared as null and void. No? Now, what are these? What are the elements of this question? One is the civil case involves facts intimately related to those upon which the criminal prosecution would be based. Okay. In the resolution of the issue or issues raised in the civil action, the guilt or innocence of the accused would necessarily be determined. And the jurisdiction to try said question must be lodged to other tribunals. No? Prejudicial questions cannot be invoked if the intention is to obtain a judicial declaration nullity of first marriage and thereafter be involved that very same judgment to prevent his prosecution from bigamy. As I was discussed earlier, that is in the case of Bobbies versus Bobbies, GR number 13859, July 31, 2000. Okay? Now, we go back to this Article 256 of the Family Code. It says that the retroactive effect of the Family Code. This code, it says that this code shall have retroactive effect insofar as it does not prejudice or impair vested or acquired rights in accordance with the Civil Code or the Family Code or other laws. No? Meaning, the law at the time of the marriage, no, the law applicable or existing at the time of marriage will determine now the validity of the marriage. No? Okay, that's why the Family Code took effect on August 3, 1988. So therefore, all marriages that took place before the effectivity will have to be governed by the Civil Code. And all those marriages that took place after the effectivity, August 3, 1998, will have to be governed by the Family Code. However, there is an exception. The Family Code says that actually this is more of a general rule. No? It shall have retroactive effect. Insofar as there is no prejudice or impaired vested or acquired rights. No? However, if you got married prior to the effectivity of the Family Code, that is August 3, 1988, of course, there's always a vested right. And so therefore, Family Code will not be applicable prior to the effectivity of the Family Code, although, of course, the Civil Code will have to be applied in that situation. Okay? Now, we will now go to this Article 40 no, of the Family Code. No? And the absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. Okay. Now there are so many cases, no, such as People versus Mendoza, People versus Aragon, Gonzales versus Lipana, and some other cases, Odayan versus Amante. These are cases that decided by the Supreme Court that somehow deviate from one jurisprudence to another. In one case, Supreme Court would declare that there is no need for the husband or for the wife to go to court and declare their marriage as void. No? It's either not necessarily this is prior to the effectivity of the Family Code, prior to the August 3 of 1988. So therefore, if you enter into a contract of marriage, and during the time that you were minor, probably 15 years old, the Supreme Court said, there's no need for you to go to court and just simply enter into a contract of a subsequent marriage to that effect, because you were 15 during the time that you got married. So therefore, you don't have to go to court and ask the court for the marriage to declare null and void. But in subsequent cases, now, Supreme Court would always say that, no, there is a need for you. You cannot declare your marriage to be void. Go to court, even if the evidence, the pieces of evidence are overwhelming. No, you were 14 years old, your wife was 15 years old. It's overwhelming. It's very basic. You were minor during that time. Do you really have to go to court and ask for the marriage to be declared null and void? The Supreme Court said yes, because you don't have the power. Rather, you don't have the you don't have the right to declare your marriage void. Let the court decide and present your case, and let the court decide as to whether your marriage is void. And so, another subsequent decision, the Supreme Court again said, no, there's no need for you to go to court. So this is quite conflicting from one case to another. However, this is already settled under Article 40 of the Family Code, which is now embodied in the case of Wagel versus Simputi. Okay? This is under 143 ISCRA 499. In this 1986 case. The Supreme Court said that there is a need for you to go to court and let the court decide. That's why this case of this Article 40 of the Family Code is actually, this came from this Gonzales, Consuegra, and Wagel cases. They just incorporated the same so that this will be settled, no? So right now, if you feel like your marriage is void, take note, you cannot declare to the whole world that my marriage is void because of these grounds, no? I was minor, etc., or suffering from psychological incapacity. Go to court and let the court decide, no, as to the fate of your marriage. Okay. Now, the totality of evidence, no, and also the expert opinion. As I was discussing earlier, there's no need for the presentation of the clinical psychologists or psychologists for that matter for your marriage to be declared as null and void, no, under Article 36 of the Family Code. So long as the judge can always determine that all the pieces of evidence are overwhelming to state that either or both parties are suffering from psychological incapacity, then therefore the marriage can be declared as null and void, no? And that is not a condition, no? It's not a condition. However, in one case, the case of Aurelio versus Aurelio, which was decided on June 16, 2011, GR number 175367, the Supreme Court remanded the case for trial in the regional trial court because the Supreme Court is not trial of facts. And of course, the judge will always evaluate the demeanor of the witness of the petitioner as to whether he is lying, telling the truth. The court, upon review of the transcript and everything, can only do so much as far as the transcript or the records are concerned. But he can no longer observe the demeanor of the witnesses and the way the witnesses delivered the testimony and everything. That's why the role of the judge is very important, because the judge can always determine whether the witness is telling the truth or telling a lie, or the petitioner or the respondent is suffering from psychological incapacity. It is now the duty of the judge to determine the existence of, one of the parties is suffering from psychological incapacity. Now, as I was discussing earlier, opinion, the testimony of the opinion is not really mandated, as also declared in the Tan Andal versus Andal. However, take note that the testimony of the expert testimony will always guide the court. No? It is now the duty of the expert witness to guide the court as to the psychological incapacity of the respondent or the petitioner. No? The petitioner saying that the respondent is suffering from psychological incapacity, then therefore he may present a clinical psychologist to support his claim that the respondent is suffering from psychological incapacity, and also the respondent saying that the petitioner is suffering from psychological incapacity. So this will now somehow guide the court in determining the truth. No, although there are so many cases that the lower court will decide that the respondent is psychologically incapacitated based on the clinical evaluation of the clinical psychologist. However, this may be reversed by the appellate court, no, is either by the Court of Appeals or by the Supreme Court, if they can surmise, no, within the trial that there's no really, the respondent is not really suffering from psychological incapacity. Now, as I was discussing earlier, no, bigamy is when you contract a marriage, no, but prior to your marriage being declared as null and void, no, subsequent marriage, no, that is bigamy. No? And another one is the concubination. No? The husband will enter into will have carnal knowledge, sexual intercourse with a woman other than his wife. No, in three instances. No, one, the husband who shall keep a mistress in the conjugal dwelling, or shall have sexual intercourse under scandalous circumstances, or a woman who is not his wife, no? Or shall cohabit with her in any other place. No? These are quite, the elements of concubinage is quite different from adultery, because adultery is a married woman having sexual intercourse with a man other than his wife, or rather other than his husband, is already considered as an adultery. Now, it is quite difficult for a husband to be convicted of concubinage. Why? Because he must prove the three nga, I was saying, maintaining mistress in the conjugal dwelling that's in the house, no? Maintaining mistress right there, or having sexual intercourse under scandalous circumstances. Now, if a man and a woman, or if a man married and is having an affair with a third person, a woman, and they checked in a hotel, and they did the sexual intercourse inside the hotel, that is not under a scandalous circumstance, and therefore that can be considered as a concubinage. No? Unlike in an adultery, if the married woman will have sexual intercourse, whether it may be elsewhere in a resort or in a hotel, that is always considered as an adultery. Now, why there is a distinction between these two? There is a distinction because it is very, very dangerous on the part of the wife to have a relationship, no, with a man other than his husband, because he can bring an offspring and to be introduced in the family. That belongs to the third person. That is very dangerous. That's why it is very easy to prosecute a case of adultery compared to a case of concubinage. No? Now, another one that I have discussed in this book is the so-called mixed marriage, no, or divorce under Article 26. Rather, under Article 26 of the Family Code. No? Under Article 26 of the Family Code, it says that all marriage solemnized outside the Philippines in accordance with the law enforced in the country where they were solemnized and valid there as such shall also be valid in this country, meaning in the Philippines, except those prohibited under Articles 35, subparagraph 2, 4, 5, 6, and Articles 36, 37, and 38. Meaning, an individual, rather example, both American citizen, if they will enter into the Philippines and they are married, they are considered, their marriage is recognized here in the Philippines. If it is valid there in the States, also valid here in the Philippines. However, it should not fall under the exceptions or prohibited under Articles 35, paragraphs 1, 4, 5, 6, and Article 36, 37, and 38 of the Family Code. Now, example, as I was telling you earlier, example, if first cousins, no, both Americans, they are first cousins who got married in the States. Assuming that such marriage is valid in the States, they went to the Philippines and they presented their passport saying that they are married to each other. Technically, as far as Philippine laws are concerned, their marriage is void. Their marriage is void because it is not valid here under the Family Code because that is void by reason of public policy. Okay, that is only an example. So we'll go to paragraph 2, which is very important. No, paragraph 2 of Article 26 of the Family Code says that when a marriage between a Filipino citizen and a foreigner is validly celebrated and a divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall have capacity to remarry under Philippine law. Okay? Now, this is called a mixed marriage. No? If the example, a German will marry a Filipina. Okay? And then after the marriage in the Philippines, they went to Germany. And then after being together for a period of time, 1 year, 2 years, 3 months, the husband now, being the German, filed a petition for divorce in Germany. And then such decree was validly obtained by the German spouse. And then assuming that the German law allows the divorcee to get married again. And so the husband, the German husband, enters into a contract of marriage with another Filipina. Now, what will happen now to his first wife, which he divorced in Germany? Now, second paragraph of Article 26 will now be applied. No? It is applicable. So he can now file a petition in the Philippines and have the decree, the decision of divorce in Germany filed in the Philippines, and so that to be recognized here under Article 26 of the Family Code, and then she must prove that there is now a divorce obtained in Germany, and such divorce, the German spouse now is capacitated to remarry. And so therefore, she is also capacitated to remarry here in the Philippines. Now, how can you establish that evidence? Now, can you just simply present in court the judicial decision or the judicial decree or the divorce decree saying, Your Honor, this is the decision in Germany saying that my husband, or rather my marriage is declared or we are divorced, and then blah, 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 blah. That is not possible because the decision or the decree in Germany must be authenticated by what? By whom? By the Philippine consulate in Germany. Because that will be authenticated, of course, by the court who rendered that in Germany, and then to be authenticated by the Philippine embassy consul in Germany, and that will now be presented here. Because as far as Philippine courts are concerned, we don't have any idea as to whether it is authentic or the decision is true. And the petitioner must also prove that the husband is capacitated to remarry. So she is also capacitated. Now, a question is posed, what if both Filipinos got married in the Philippines and then the husband became German or American, naturalized American for that matter, and then the naturalized American obtained a divorce in the States, and now enters into a subsequent marriage now to another Filipina. Will that be possible? Because the law says it should be mixed marriage. No? It is possible because what is determined here is the citizenship of the parties during the time that the divorce is obtained. No? So during the time that divorce has been obtained, the former Filipino became a naturalized American. During the time that the decision was obtained, he was already a naturalized American. So therefore, Article 36 of the Family Code, no, second paragraph, will also be applicable. Okay? Now, lastly, in the book, I have also discussed the elements of in a petition for declaration of nullity of marriage under Article 36, or even other grounds for that matter, Article 35 and other grounds. There should be no default, okay? No compromise agreement. There can be no motion to dismiss. No? Judgment on the pleadings is not applicable. No? Summary judgment is not also applicable. The confession of judgment. Meaning, take note that the husband, if he files a petition of declaration of nullity of marriage and the wife did not file her answer, he cannot file a motion to declare defendant of the respondent in default simply because the wife did not file her answer. That is not possible because because the state will always intervene through the Office of the Solicitor General, delegating now the Office of the City Prosecutor to intervene in the petition for declaration of nullity of marriage, not because that it will protect the interests of the respondent, but it will protect the interests of the state, and that the evidence are not fabricated and there is no collusion, meaning there is no agreement as to both parties that they would file a petition for declaration of nullity of marriage so that their marriage can be declared as null and void, so that they can go and separate ways peacefully and have their respective lives and go with their respective partners if there are. It's not possible. It is always the duty of the state, no, through the Office of the Solicitor General, delegating the Office of the City Prosecutor, no, to determine if there is no collusion and if the piece of evidence are fabricated. That's why even if the wife or the husband, no, who is the respondent in this petition, will not appear in court, so the petitioner now will present his evidence ex parte. It's not possible. No, he cannot present his evidence ex parte. Ex parte meaning without the other party. He cannot present his evidence ex parte. He must still prove his case in court. And this office and the city prosecutor now will now intervene, and then the petitioner and his witnesses will have to be cross-examined by the state, no, through the Office of the Solicitor General, and to determine now whether there is any fabrication of evidence that may have been introduced by the petitioner, and there is no that or there is an agreement, no, as for them to go with this declaration of nullity of marriage. I think I have already discussed the purview of the book, and I hope this book will also help the practitioners and law students and even laymen. Laymen will also can avail of this book and can read this, because you can always appreciate the ins and outs of this psychological incapacity, because this is one of those introduced under the family code under Article 36 that is so new to us, no? It is new because it was not part of the civil code, no, before the effectivity of the family code, and it's still an evolving thing as far as jurisprudence are concerned, no? That's like in the case of Tan versus Andal, Tan Andal versus Andal, no? That is a recent case that we have to read, of course, first the entire decision for us to know what are the obiter dictum of the Supreme Court. With that, thank you very much, and have a good day, everyone.
Thank you for the very rich presentation, Attorney Tumuran. We are very honored to receive such expert guidance, especially at a time when the study and practice of law have become more challenging. In behalf of Rex Education, allow me to congratulate you on yet another in your cap with the release of this book. We look forward to learning more from you through your books and lectures. Congratulations, Attorney, and here's to more years of working together as stewards of legal education.
Thank you very much, ma'am.
All right, please be informed that you may ask questions to the speaker by typing them in the comment section. There will be time allotted for Q&A at the latter part of the session. And now, we are very honored to be joined by another legal expert. Let us hear more about how the works of Attorney Tumuran can be used for an optimum learning, especially for the upcoming bar examinations. Let us all give a warm welcome to Attorney Rodolfo Tagapan, Officer at Integrated Bar of the Philippines, Quezon City.
Good afternoon, ladies and gentlemen. I am honored to be invited by Rex Bookstore and Attorney Edinburgh Tumuran to share my thoughts on his well-written, well-researched, and comprehensive book entitled Psychological Incapacity, Genuine Happiness, and Authentic Grief of Marriages, Its Nullities and Clinical Basis. I will no longer discuss two parts of my testimonial, because the first two speakers already dealt on it, and that Attorney Dong, if I'll recall him, Attorney Dong, already lengthily discussed an overview of his book. So I will just limit my talk, my testimony regarding my appreciation of this book. But before that, let me just discuss briefly saan ba galing itong Article 36, Psychological Incapacity, for the benefit of those who are not yet aware. Well, during the deliberations on the Family Code on Book 1, there were framers who were advocating divorce, but a good number also of experts believe that at that time our country is not yet ready for divorce. So in order to strike a happy compromise, they came up with this psychological incapacity. Is the psychological incapacity a new concept? No, it's not. Psychological incapacity is lifted from the canon law. If you are a Catholic and got married in a Catholic ceremony, even if your marriage is declared null and void by the civil court, you cannot hold your marriage, your second marriage, to the church. You must undergo a church annulment so that the principles of the canon law is adopted by this psychological incapacity thing. Okay? Now, I've been a practicing lawyer for more or less 27 years. And one of my area of specialization is marital cases, the bulk of which family relations, and the bulk of which deals on marital issues such as psychological incapacity or annulment of marriage. As law practitioners dealing on marital cases, we need to be the best that we can be for the sake of our clients, especially those who are victims of failed marriage. And reading the book of Attorney Dong Tumuran, I fondly call him Dong, this book is really a must-read book for all well-meaning lawyer handling annulment cases. This book should be in the library of every law offices. I have read the book and I am mesmerized by the level of detail as it discusses with matching jurisprudence all the aspects or issues affecting an annulment case. This book is very helpful, especially to new lawyers, especially to practitioners who have no experience on marital cases, especially annulment case, because this book contains everything that you need to know about how to prosecute an annulment case, because it has provided all the information and authorities needed to deal or to prosecute an annulment case. Attorney Dong a while ago mentioned about that Supreme Court decision whereby the Supreme Court adopted the totality of evidence rule. Actually, this concept is not a new concept. Way back in 2009, the Supreme Court already decided this concept of the totality of evidence rule as held in the case of Ascueta versus Republic of the Philippines, which is also lengthily discussed in this book. Okay? For practitioners dealing on marital cases, the totality of evidence rule should now be the concentration of every lawyer handling marital cases. Why? Because, as previously mentioned, discussed by Attorney Dong, it already done away with the expert opinion of psychologists and psychiatrists. Now, in the case of Villalon versus Villalon, the totality of evidence rule was also applied in that case. And ano ba itong totality of evidence rule? Okay? If you want to know about the totality of evidence rule, you must read this book of Attorney Dong. Just flip page 95. And there, Attorney Dong discuss everything about the totality of evidence rule. As I said, in the case of Villalon versus Villalon, Petitioner Villalon even presented an expert witness, and that expert witness used the Casanova complex in order to prove that Petitioner Villalon is psychologically incapacitated to comply with his marital obligation. Initially, the regional trial court granted and adopted that Casanova complex. However, the respondent elevated the matter to the Court of Appeals, and the Court of Appeals reversed the trial court. And Villalon brought the matter to the Supreme Court, and the Supreme Court affirmed the decision of the Court of Appeals, reversing the decision of the Regional Trial Court granting the petition for declaration of nullity of marriage under Article 6, because according to the Supreme Court, Villalon failed. The totality of evidence of Villalon failed to prove the psychological incapacity on his part. So this is very important. That is why I'm so happy that this book came out, because all practitioners, even new ones now, can earn a lot of money by way of attorney's fees handling psychological incapacity, because psychological incapacity is a very good source of attorney's fees for practitioners, because unfortunately, we have a lot of marriages breaking down. And that is why we have now a special court like family court dealing on this matter. And a new lawyer, as I said, a new lawyer, a practitioner who has not handled psychological incapacity, all they have to do is read the book of Atty. Dong. And then I'm sure they could get a favorable decision following the all the all the advices and the principles laid down in this book. So, in fact, yesterday, a client just came and see me, and she was opting or inclined to file an annulment case. You know, when I was with my client, I thought that I feel that Atty. Dong is beside me, whispering to me, what should I tell to my client? Because while we were discussing, the facts of my client, future client, I recall all those principles, those facts, those opinions rendered in this book to really address the concerns of my client. And that client was smiling and happily left the office very happy and looking forward to a promising life. So I recommend this book for all lawyers, for all law practitioners, new ones. Don't be afraid to handle psychological incapacity cases or annulment cases. All you have to do is to read by heart this book of Atty. Dong. Sabi nga all discarded lovers should be given a second chance, but with somebody else. Good things happens only when something ends. And with that, congratulations, Atty. Edinburgh Tumuran, for coming out with this book, your second book, because you have written an earlier book on HLURB jurisdiction, which is also very helpful for real estate practitioners. Congratulations for coming up with this book, and for to Rex Bookstore for publishing it. Thank you, and good evening and good afternoon.
Thank you for all of these kind words, Attorney Tagapan. Hearing your praises of the book gives us utmost pride for having been chosen and entrusted with the publication of this masterpiece. In the same vein, allow us to express our gratitude to you as well for being stewards of legal education and of law practice yourselves. All right, now we're opening the floor for the Q&A with our author, Attorney Edinburgh Tumuran. So feel free to comment your questions below. We will be selecting 3 questions from the comments. And as we move forward, I will be reading the questions in your behalf, attorney.
Okay, ma'am.
All right, attorney, we have a question from Ms. Joanne Padilla Santa Ana Awingan. Her question is, can we say that our law is double standard when it comes to adultery and concubinage?
Okay. Thank you for the question. No? Well, I can say is that is not the case because there is a need for the parties, no, to rather it is very important for us to understand why there is a differentiation as far as the grounds for concubinage and adultery are concerned, because it is not double standard. Because try to imagine if the wife will have sexual intercourse with a man other than her husband, and that wife now will introduce a child to the family. No? That is not that the father is a different person, not the husband. So there is no double standard there. There's no double standard there because it presupposes that the law also protects the sanctity of the family, no? As a basic social institution. Although concubination and adultery is part of the revised penal code, and revised penal code was based on the Spanish civil code, Spanish revised penal code. Nevertheless, it is still important that the definition of the concubinage is different from adultery. So I can always say that there is no double standard as far as these two criminal violations are concerned. Thank you.
Thank you for that, attorney. And we have another question from Miss Leonila Plazos. Her question is, how about if a married man stayed in another house with another woman and he did not give support to his family? What case can be filed to him? Thank you.
Well, it depends, no? The case, meaning the case that will be filed against the husband, no? Well, of course, if there is a need on the part of the wife to be supported, no, you can ask for support in court. No, that is a civil case. No, or if there is no support, then it is a possibility that a case for vowsy, no, can be filed also against the husband, no? And that is a criminal case. However, criminal cases is quite difficult to prove in court, no, compared to a civil case. Now, you have to determine first as to what is your need. No? What is the need really of the wife? No? Whether to send her husband to jail and languish there, and at the end of the day, if the husband languishes in jail, she can no longer be supported by the husband because the husband is no longer working. But if the wife now can file a petition for support against the husband, then that is a possibility because if the wife cannot sustain her daily needs, no, sustenance, no, then he can always ask the court and file a petition for support against the husband. Of course, that also includes their children. So the best way is the best remedy there is to file a petition for support. Thank you.
Thank you for that, attorney. Do we have any more questions from our viewers? Any clarifications you want to ask attorney? Feel free to comment your questions on the comment section below. All right, attorney, I believe we don't have any more questions. So anything you would like to say before we proceed with our online raffle, attorney?
Yes, I would like to thanks, of course, Rex for giving this opportunity. Actually, this is my second book. The first one was the HLE Orbis Jurisdiction. It's being revised right now because in the advent of this RA 1101, no? The creation of the Department of Human Settlement and Urban Development. No? And it's quite difficult on my part because when I started writing this book, that was about 2 years ago. And it seems like taking me forever to finish the book because I was heavily involved into triathlon and doing my training every day, swimming, biking, and riding. It's quite difficult now, even during the weekend. But when ECQ that was declared last year, it was an opportunity for me to finish the book. So during the ECQ, I was able to finish the book and somehow managed to submit the manuscript to Rex. And again, thank you very much for this opportunity and looking forward for another book to be published by Rex. Thank you very much and good afternoon.
All right. Thank you, Attorney. And once again, congratulations.
Thank you.
All right. This time, as promised, we will now be giving away a copy of this new book. Who will be the lucky one to win the book Psychological Incapacity, A Genuine Happiness and Authentic Brief of Marriage, Its Nullities and Clinical Basis by our beloved Rex author, Attorney Edinburgh P. Tumuran. Again, reminder, we will be announcing the name of the lucky person for this raffle. If your name is called, comment down present so we know you're here with us. We will then verify if it's you who won, but however, if after 30 seconds we did not see any comment, we will be drawing another winner from our list of registrants. Also, those who already won the raffle last book launch is not allowed to join the raffle anymore so that we can give chance to the other registrants who's here with us today. Good luck! And we have a winner. Congratulations to Miss Feme Garote. Miss Feme, if you're here with us today, kindly comment present on the comment section below so that we can verify that it's you. We will be giving you 30 seconds to comment down present for you to be able to win Attorney Tumuran's new book. All right. Unfortunately, Miss Feme was unable to comment present during the allotted time, so we will be drawing another winner. So those who registered, you still have a chance to win Attorney Tumuran's new book. All right, we have a winner. Congratulations to Miss Myra Napilot. Ms. Myra, if you're here with us today, kindly comment present on the comment section below. We will be giving you 30 seconds only to comment present. Once again, congratulations to Ms. Myra Napilot. All right. Congratulations, Ms. Myra Napilot. You have won a copy of the book Psychological Incapacity, A Genuine Happiness and Authentic Grief of Marriage, Its Nullities and Clinical Basis by Attorney Edinburgh Tumuran. All right. So a Rex representative will be sending you an email for the details on how to claim your prize. Once again, congratulations to Ms. Myra Napilon. On that note, we have come to the end of this afternoon's program. Indeed, it was a very productive learning afternoon with our legal luminary, Attorney Edinburgh Tumuran, and our distinguished guests from the field of law. In behalf of Rex Education, I would like to express our heartfelt gratitude for having been chosen as your partner in legal education. We look forward to more years of our fruitful partnership as we continue to work together to enable law students and lawyers achieve their dreams of becoming lawyers and excelling as one. So everyone who joined us this afternoon, thank you for learning with us and for choosing Rex to be your partner in learning. See you all on our next book launch and lecture. Thank you and keep soaring, Edu Campeones.